We're going to get started. And again, thank you and welcome. We want to introduce Kaylee Chivers as our new intern who's working for the association. We're glad to have her here with us. And of course, John Darby, who is our executive director back there in the computer in the corner. And of course, we want to thank our host pastor, Pastor David Myers, for hosting us today and tomorrow. We greatly appreciate that. And we will hear from him in just a minute. I do want to say that on your table in front of you is one of his books. And all you need to do is give John Darby $20 for that book. Or if you don't want, you can give it back to him and tell him you don't like Brother Myers. And just briefly, our schedule today. As soon as Brother Myers welcomes us, we're going to turn it over to Brother Michael Bland, who is from Denver, Colorado, and practices in estate planning. He's going to talk to us about estate planning issues and has had a handout. Following him, we have Brother Pastor Hector Gonzalez from Colorado, who is a pastor, and he is an immigration lawyer, going to talk to us about immigration issues. And then following that, we're going to have perspectives from the bench, and we are honored to have Supreme Court Justice Jennifer Branning from Mississippi, and she's on her way. She'll be here before her session, but she'll be speaking with us at 4:30. Following that, we're going to have address from Bishop Boyd, who's the district superintendent of the Florida District of the United Pentecostal Church, and we are fortunate to have with us this evening Brother Jerry Jones, former, I believe, assistant general superintendent or secretary of the United Pentecostal Church, and he'll be with us and address us following that, and then we're going to dinner at Carrabba's. Your family members who are with you are welcome to join us, and we have a reservation, so we're looking forward to having everybody at Carrabba's. Tomorrow morning, we'll start at 9 o'clock, and we've got 3 sessions before lunch, and we expect a good crowd of ministers that will be here. And then following lunch, which is going to be brought in here, we're going to have an attorney panel. So those people who are speaking today will be on that panel. We'll have question and answers from the audience for those attorneys. Whatever legal questions they may have, they can ask at that time. But with that, make sure I didn't miss any of my notes. Also, I do want to say, and they're not here yet, so I was waiting for them to say this, but the Stewardship Department of the United Pentecostal Church is co-title sponsor of this. They're going to be recording, and these seminars will be available on our website as well as through Stewardship. They intend to use that, and we have a new joint venture that we're working with them to try to get them information to help the Stewardship Department with their task and what they do for the organization as well. So with that, thank you again for coming, and I'd like to turn it to our host pastor, Pastor Myers, to come and address you.
Thank you, Brother Plappert. Appreciate Brother Plappert and Brother Darby and all the work that they're doing in getting the Apostolic Legal Association up and going. And this is a tremendous ministry where we can network with those that are in the legal field. And we're excited about this because we do feel like it has received its endorsement from the United Pentecostal Church. So it's an endorsed ministry. And we feel like it'll keep growing. And so we're glad that y'all are here. We're so happy to have Bishop and Dr. Myers with us. And we're thankful for these great people, my mom and dad. And so we first came here in 1971. I was in 3rd grade. And my father took a little church of about 4 or 5 families. And before that, they had pastored up in the panhandle of Florida in a little town called Port St. Joe. Had about 3,000 people in it. When we moved here, they were launching rockets up the road and going to the moon, and Disney World was open up, and we thought we had moved to New York City. But back then, Palm Bay was only 5,000 people, and now it's 145,000. So we've seen a lot of changes over the years, but God's blessed, and we appreciate their foundation. And my father's 90, and he still teaches the Word of God. And my mom is a doctor of mental health counseling and has all kinds of clients and works harder than all the rest of us put together. So we appreciate them. We're glad they're here. And we're so glad you guys are here. Let us know if there's any way at all we can host or anything we can do to make you guys, your stay more enjoyable. Any suggestions, restaurant, whatever we can do to kind of acclimate you to the area. That's what we're here for. The book, what we're doing with the book is just donating it all to all the proceeds. They don't go to us. They just go to help the Apostolic Legal Association. And so that's just came about when I was in law school. because my background, of course, was in ministry and pastor and evangelizing and all of that. I started seeing all these parallels between our jurisprudence system and the Bible. Contract law goes back to the covenants when we're anyways, that's what that book is about. It's a lot of the parallels between Scripture and our American jurisprudence system. So, thank you. Glad that you guys are here. And we'll pray and get started, and I'll turn it back over to Brother Plappert. Lord, we're thankful for this opportunity to be with our brothers and sisters. We're thankful, Lord, for this ministry that you've given us where we can help people. I ask you, Lord, that you would be with us in these sessions, both today and tomorrow. And let everything that we do bring glory and honor to you. In Jesus' name we pray. Amen. God bless you.
Thank you, Brother Myers. And welcome, Bishop Boyd. Great to have you with us today. It is my honor to present to you Michael Bland, who is a principal with Harrison LLP. He is out of Denver, Colorado. And my claim to fame, Michael's a little bit younger than I am, but he was in my Sunday school class at one time. I was his Sunday school teacher. So God bless you, Brother Bland.
Thank you, Stan. It's good to be here with everyone. And how many CLE programs do you start with prayer? I mean, I love it. This should happen more often. So it's really good to be here with everyone. And, you know, I've known Stan a long, long time, going back to the Sunday school days. He was the one who convinced me to come to where he was living at the time to go to undergrad in that town. I actually worked for Stan in his business many, many years ago. Still like Makita Tool, Stan, by the way. So we go way, way back. So it's great to be here with you all. A little bit about my background. So I started practicing 1993, downstate Illinois, farm country, and in a very small law firm of 4 attorneys. And so 1993, the job market was really, really tough. And so I was blessed to even have a job coming out of law school. A lot of my classmates did not even have jobs. And so I was just grateful to have a job. And so family was all there and so forth. I was there for many years, started doing estate planning kind of out of the box there. Had an opportunity to move to Colorado in 2000. So from there I joined a firm that had about 20 attorneys. So that was a big change from 4 to 20. And it was kind of a boutique firm that did estate planning, buy-sell types of arrangements, selling businesses and so forth. Then ultimately, from there, I got recruited over to head up the planning practice for a regional firm that had 240 lawyers, not all planners. So that was a big change. That firm ended up merging in with a large national firm that had 1,000 lawyers. So I was kind of swimming upstream. Most people go the opposite direction. I'm not sure why I took this path, but that's the way God had it for me. But it was kind of cool. That firm ended up merging with a UK firm that had 600 lawyers, so it had 1,600 lawyers. And in 2000, right before COVID hit, I thought, what in the world am I doing here? This is not really what I envisioned, and I wasn't particularly happy in big law. Now, no offense to anyone who's in big law here. But it's just, to do estate planning in big law can be challenging. Even to open a file, the conflict process can be super challenging. Long story short, I decided to leave. I'm not going to take the time today, but how God opened the doors for me to be in Harrison and what has happened the last 5 years since I've joined, not because of me, but I feel like because of God's blessing, is really, really cool. So we're kind of a national boutique planning firm. We have offices around the country, and so it's a blessing to be there to work with clients and help them solve kind of problems. So I tend to with high net worth individuals, ultra high net worth, but I also do smaller estates as well. So whatever kind of comes in the door, what makes sense for the client. So we're going to be talking today about various estate planning topics. But since this is an apostolic event, did you guys know or realize that estate planning is referenced in the Bible? How many knew that? Yeah? Okay. Yeah? There we go. There you go. So, and just for my reference too, who are the attorneys in the room? Make sure I understand who the attorneys are. Okay. Good. Okay. So, and if you're not an attorney, that's okay. Some of the things we're going to be talking about today, when it's time to either do your estate plan, hopefully you've done one, or if it's time to review, hopefully these concepts will be helpful at that point in time as well. But so, estate planning is mentioned in the Bible. Let's start first with some references to some terminology. Descendants in the Bible. And I only listed one of the many scriptures that are in the Bible with some of these terms. Heir, inheritance, all of these are in the Bible. What about birthright? Not a modern estate planning term or theory, but it kind of reminds me, and I've not done an in-depth study on this, but it kind of reminds me a little bit about kind of some of the forced heirship rules, perhaps, that countries like perhaps maybe Mexico or others, that have a certain way of how assets have to be distributed as part of estate planning. What do we call a document that leaves assets when we die? Real easy, right? A will. And a last will and testament. Well, Webster defines testament as an act by which a person determines the disposition of their property after death, or either one of the two main divisions of the Bible, right? Or a covenant between God and the human race. So, there's some references there. How about this scripture? Have you ever noticed this one before? Hebrews 9:16 and 17. For where there is a testament, there must also of necessity be the death of the testator. Testator is the creator of a will. For a testament is in force after men are dead, since it has no power at all while the testator lives. Wow, God knew about estate planning long before we were doing it, okay? I mean, how many has tried to take a will while someone is alive and probate that? Does that work very well? You probably get thrown out of court, right? So that doesn't tend to work very well. Now, if I got to thinking too about people in the Bible and what their estate planning might look like. So let's start with going back to the very beginning. You're a new attorney. Adam and Eve walk into your office. Want you to help with their estate planning. Okay? Name, Adam, Eve. Children, Cain, Abel. Okay? You want to provide for each other, leave everything to each other. How are you going to take care of your children? Oh, we want it to be divided equally, right? That's how most people do it. Doesn't mean you have to. Well, who's going to be in charge of your estate after you both pass? Oh, I think I want to name Cain and Abel as co-executors of the estate. Not sure how well that's going to play out. Or how about this one? We've got a blended family situation here. We've got Abraham, Sarah, sitting down with you doing their estate planning. Children, Isaac. Anyone else? Yeah, Ishmael. Yeah, he fits in the equation. Well, how do you want to leave your assets to your children? Well, Abraham, of course, equally to my children. What do you think Sarah would say? You think she wants to do equally to the children? No, okay. So that's kind of a blended family example. How about this one? Jacob. Okay, Jacob in the Bible. He's got a couple of wives, so we're going to take this as a separate representation of just Jacob alone. We're not going to try to represent the whole family. It gets really complicated from an ethics standpoint. All right, Jacob, you got a lot of children. How do you want to provide for your children? Oh, I want to leave it all to, Joseph, including a new coat of many colors, right? So my goodness, how do you think the other children are going to react when Joseph inherits everything, including a new coat of many colors? Any litigation there, by chance? Probably so. And last example, before we get into some of the modern planning here, what about the son of the prodigal son? He comes in for estate planning. How many children? 2 children, okay. Yeah, and he tells you that the youngest son wants him to make some gifts. Well, how much of a gift? Well, his half of the inheritance. When? Early, now. What about gift taxes? Is it going to be made in trust or outside of trust? I mean, how's this going to happen? Well, he just wants it now, outright. Maybe if he had put it in trust, he wouldn't have ran into problems. I don't know. But these are some things from the Bible that if they did estate planning back then, maybe it would have helped, maybe not. So now into our discussion today, and I've got way more material than I'll probably ever cover in an hour, but we're going to first start with kind of a case study. So for you lawyers in here, if you do, anyone do wills, prepare wills? Okay, so this is probably old hat for a lot of you. And so I'm going to walk you through my processes. There's no right or wrong way. Everybody has their different things. And having attended a national conference just last month in Orlando, a whole week of CLEs, after which your brain feels like mush. And generally, I hope if I can get 1 or 2 points out of each class, or even a few in a week, that's pretty good. And so that's what I'm hopeful that today, that I can leave you with a few practical pointers or things that you might consider. And if you're not an attorney, maybe there's some things in here you can think about for your own estate planning. So obviously, you get a call, someone wants you to help with their estate planning. I'm going to run the conflicts. I'm not going to walk through that. Important to do that. Well, how did the prospective client come to you, right? Tiny tip, but I mean, I like to kind of track to some extent where's my work flowing from. I know that God ultimately provides, but it's helpful sometimes. I want to send a thank you note, acknowledge that. Kind of gives you some idea where the work's flowing from, whether it's an outside referral source, whether it's an existing client, whether it's children of an existing client, it's an internal referral, so it's always helpful. What about an engagement letter? We always got to do that. Well, who do you represent? In estate planning, this can be tricky. Oftentimes when you're representing a married couple, you're representing both, but there are inherent conflicts of interest when you're representing a husband and wife, and you have to be really, really careful with that. I'll share a few war stories as we go along as well. So I had a situation a couple years ago. Get a call from a prospective client introduced through a financial advisor, and we talked on the phone. He said, yeah, I'd like help reviewing my estate plan. And, talked a little bit. Well, what will we be doing? Who will we be representing? Are you married? Yes. Will we be representing your wife? Oh, of course. Got to represent the wife. Okay, so set up the engagement letter, send it out, schedule a time to meet. Time for the meeting shows up. Husband walks in, no wife. Oh, okay. Could she not make it today or what? No, I need to talk to you. We have marital issues. Okay, so what does that do to your representation? Lots of issues right then and there, so it can be problematic. The example I had a situation when we talked about Joseph and his situation in the Bible. I had a client a few years ago that husband and wife sat down together trying to do their estate planning. Well, how are you going to leave it to the kids when you're gone? Wife, of course, wanted to leave everything equally to the kids. Husband, on the other hand, business owner, not so much. I don't know what happened in the business before I got involved, but he had some really unusual dispositions. Like one of the 4 kids was getting like 5%, and so it was very disproportionate. So had to kind of work through some of those issues to be careful on the representation side. Well, how do you think that plays out at the end with the kids? Can be very, very interesting. Well, how are you going to get paid? Are you doing hourly, fixed fee, some type of a hybrid? I mean, it's not uncommon for estate planning attorneys to use, kind of a combination of those. Are you asking for a retainer? Obviously, you need to get paid unless we're doing some type of pro bono work. I like to send out questionnaires in advance to try to gather some information from clients to try to be as prepared as possible. Probably in part, too, I feel a little guilty to be sitting there asking clients like the names and spellings of their children's names, their birth dates, and it just seems a little inefficient. So sending out questionnaires to gather information about them, and then also requesting pertinent documentation that might be relevant to the representation from executed estate planning documents. Maybe they have marital agreements, state tax returns from a spouse who passed away, gift tax returns, pertinent corporate documentations. I like to ask the names of their other advisors, their CPA, their financial advisor. Who are they working with to have a collaborative types of effort? Doesn't mean you're always in contact, but from a team perspective, you generally end up with a better plan, in my opinion. Questionnaire talks about goals and concerns, assets. We're going to talk about some of these more in detail. So we send out our questionnaire. It comes back. So what do I typically do to prepare for this initial meeting? Well, you're going to review the executed estate planning documents. Now, let's pause here for a second. What if their will is from 1990? Should you review that? Maybe. If it's a revocable document, meaning something that can be changed and it's quite dated, what I typically do with clients is I'll ask them and tell them, like, the odds are we're probably going to update this in a major way, maybe completely restate it. So does it make sense for you to pay me to review this? I will. I'm happy to do that. And kind of leave that to the clients. Obviously, with irrevocable documents, you need to do that, but maybe first confirm, are there assets in these trusts to make it worthwhile to even review as well? So kind of preparing yourself to have discussions about the documents that they have. Tend to review the family information that's provided, spotting various issues. I like to spend a fair amount of time on the client's goals and concerns. You got a business, succession types of planning issues. Are you worried about estate taxes, troubled marriages for kids? A lot of different things kind of are in that questionnaire that will allow me to focus my time and attention to those issues, so I'm not trying to cover every conceivable estate planning topic in just one meeting, because they would exhaust them and me. Finally, when we generally request financial information too, and generally sometimes they'll provide a personal financial statement, a balance sheet, which is always nice and helpful. But as you know, that generally doesn't tell you how the assets are titled. It also doesn't tell you, are there any beneficiary designations associated with those assets, which are very, very important to that process. I also like to prepare a meeting agenda, and we'll see a very simple example here in a moment. Some other basic things, just I'm sure you've thought about, but who attends the meeting? Oftentimes, whether it be the CPA or perhaps financial advisors, they like to attend, but you got to be aware of confidentiality types of issues by having non-attorneys attend those meetings that are not clients. How are you meeting? Pre-COVID, it was almost always in the office. Now, not so much. So obviously clarify that. Who's taking notes? Are you the one taking notes? I do that if I have to, but if I have the option and the client circumstances support having another person in there, whether it be an associate or a paralegal, tends to allow me to listen more proactively. AI is becoming a big thing today, but there's obviously ethic issues surrounding the use of AI. Is it secured? How is that handled? So some new issues that we got to think about. And just a final practical tip, I like to have my assistant confirm meetings in advance as well, not only make sure they understand parking directions and where the office is located if they haven't been there before, but also just to confirm, I mean, it doesn't happen too often, but there's nothing worse than preparing for a meeting and there's a no-show, because it tends to be not overly efficient use of anybody's time. Here's a very simple planning agenda for a very basic plan. Then we're going to go through some of these different steps in detail. And the point of me doing this really is, obviously the more complex it is, the more valuable it is to allow you to kind of keep the focus on what the meeting's about, add things that may be pertinent that you don't want to forget, things of that nature. But when I meet with a client, one of the first things I'm going to ask them, after you get through the preliminary discussions and pleasantries and so forth, is, are there any burning questions on your mind? Because you may have great ideas based upon their factual situation or what their goals they've explained to you, but if they got a burning question, they may not be really actively listening to you and ready to fully engage until you at least give them the opportunity to ask those burning questions. All right, moving on to a very important part of estate planning that's often overlooked is confirming the assets and what they have, liabilities and so forth. And the reason why we do this, because you can prepare the world's greatest estate plan, and we hope that we do, right? Beautiful, perfect language, no ambiguities. But if the assets aren't coordinated in such a way, you could have a very scattergun, shotgun approach with your estate plan. So it's important to understand what assets they have, how they're titled. Are the assets titled in joint tenancy with rights of survivorship, which means that's a non-probate asset, passing automatically by operation of law to the surviving owner? Is it held by tenants in common, which creates probate issues? Is it held in one or both revocable trusts? What assets are marital assets or separate property assets? What if you were to advise clients to gift certain assets, but you're basically inadvertently transferring something that is a separate property asset into a marital category, and then heaven forbid the couple separates? That they probably wouldn't like you too much at that point. Do they have community property assets? Are they from states like California, Arizona, Texas? That you got to be aware of those issues. Are the clients even amenable to transferring title? I mean, you might have a great idea for saving them loads of taxes, but if they insist on having everything owned in joint ownership, you're probably wasting some time. So it's just helpful to have that. You know, what assets have beneficiary designations? Who are those beneficiaries? Oftentimes I find that clients, it's many years since they've even looked at these types of things. What about, are they the beneficiary of another trust in some way, if you don't ask those questions. Maybe they have an estate of $250,000, doesn't seem very large, but they're a beneficiary of a $10 million trust. Probably need to look very closely at that trust. What types of options and controls do they have to make sure that you work with them on that? What about if I always ask if parents are living, because you might want to know what does the parents' estates look like. You may not know in great detail, your clients may not know, but let's say that you already have clients in a taxable estate situation and their parents are going to leave them another $5 million. Well, the government's going to take $2 million of that just because somebody didn't look upstream to see if there's planning opportunities to minimize the taxes all the way through. Speaking of taxes, got to consider estate taxes, right? Not just at the federal level, but even at the state level. Not every state, in fact, very few states have estate taxes. Our home state of Illinois being one. Tend to be mostly blue states, but there's a few red states. So you got to be aware of estate tax issues. Let's talk about estate taxes. Oh my goodness. From the time I started practicing, the estate taxes have been all over the board. When I started, I don't mean to date myself here, the estate tax credit or coupon was $600,000. It is now $15 million per person. So a lot of changes there. And you can see with this chart here, it has gone up and down, and speculation, is it going to go away, is it going to go up? So with the recent tax legislation last year, it has now become permanent, indexed for inflation at 15 million until the next political party gets in control and wants to change it and do it all over again. So it's permanent for now, but stay tuned. I also have a reference here about the annual exclusion amount. That's the amount that you can gift tax-free, $19,000 per person per year. I'm accepting donations if anyone needs an extra beneficiary here. And there's also other ways that you can leverage those gifts beyond the $19,000. So that means a married couple, that's $38,000 per year. Plus you can make gifts of qualified educational expenses, medical expenses directly to providers. That's a way to further leverage that amount. It's not counted against you. And if you happen to have this as a more advanced planning topic, but a intentionally defective grantor trust that you've set up, you can pay those taxes. That's another tax-free gift. There's a lot of different ways to kind of leverage that. So with the estate tax side, if we each get $15 million apiece, that's $30 million in theory a couple could have without having to pay any estate taxes. So that's quite high. Well, we can see it could be lower than you think. So in our example here, there's this concept that came about in 2010, the concept called portability. So to do traditional estate tax planning years ago, it was kind of a use it or lose it type of regime where you had to use the coupon in a way by either giving it the assets outright to children or some other non-spousal beneficiary that was not a charity, or in a trust for the benefit of the spouse that kind of qualified for this estate tax credit and use. And then when portability was introduced in 2010, becoming permanent in 2012, it was a way of really simplifying so you didn't have to do as many complicated trusts and so forth. But you still got to be careful if you're working with clients that are less than that, because you might think, well, I have up to $30 million and I have to worry about estate tax. It's not true. So here, I'm going to go through a quick example here. So this example, spouse one dies with a $15 million estate. Ironically, the exact same amount as the current level of estate tax coupon today. It's gifted all to the surviving spouse. You can leave any amount to a surviving spouse through the unlimited marital deduction, even $1 billion, no estate taxes due. But in our example, $15 million left estate tax free. No estate tax return is filed, which is required for this portability concept. So spouse two now has $18 million because they had three plus 15, you got 18 million total. Spouse two dies with a $15 million estate tax credit. So the kids get $16.8 million, paying $1.2 million in estate taxes. Okay, could that have been avoided just by a little bit of planning here? Yes. And here's here's a couple of ways. Number one, the second example here is we leave it through a more traditional tax planning trust. When spouse one dies, it goes, that $15 million goes into this kind of a special family trust, and it's not counted against spouse two. So when spouse two dies, there's only $3 million in his or her estate, thus having a $15 million tax credit, leaving no estate taxes whatsoever. Or with portability, this more simplified process, spouse one dies, we file an estate tax return to elect portability so that the surviving spouse gets that estate tax coupon to continue to carry forward. So when spouse two dies, they don't just have a $15 million coupon, they got the full $30 million with an $18 million estate, meaning zero estate taxes. I think the clients would probably be a little more happy with that second example as opposed to paying $1.2 million because we didn't file for portability. So something to keep in mind. Talk about the client goals and concerns. We're not going to get into a lot of specifics about that other than say when you go through if you're reviewing estate planning documents, what I find it helpful, if you know what their goals and concerns are up front and you've read their estate planning documents, it's very easy to say, okay, here's where there's a disconnect I see in their estate planning documents where you either need to do a codicil, a trust amendment, or maybe a complete restatement because your current goals are not carried out in this plan whatsoever. So we're now going to go into some design questions in a foundation estate plan, and I'm going to use a revocable trust-based plan for this purpose. And when I say a foundation estate plan, that typically means either a will or will revocable trust, financial powers of attorney, medical powers of attorney, and a living will. There's other kind of basic documents that typically are included, like a HIPAA release, personal property memorandum, many other joint tenancy agreements. I'm only going to focus on these documents here, not all of them, or we would be here all day. Let's move into, do you use a will or a trust? Because you can do essentially the same type of estate planning with a will or a trust. It really depends upon coming back to the client's goals. And just to clarify too, when I say revocable trust, that is different from an irrevocable. So revocable meaning that the client can change it literally the next day or amend it as they wish, like a will. So when I look at the client's goals, if their goals are to avoid probate, that tells me revocable trust plan. What is probate? That's the court-ordered process to allow an orderly disposition of probate assets. If their goal is to avoid ancillary probate, that would be another reason to use a revocable trust. Well, what's ancillary probate? Well, if a person dies in, say, Florida, and all of their assets are in a revocable trust, but for their cabin in Colorado, you may not have probate in Florida, but you're going to have probate in Colorado because the real estate is owned in Colorado. But if that real estate was owned in either an LLC or a revocable trust, then we would not have that probate in Colorado. So that's another reason to use a revocable trust-based plan. Another critical reason that I often find with clients is to keep the estate plan private. If your whole estate plan is set forth in your will, when you pass away, in many states, at least it is in Colorado, your will is recorded in the county where you live and becomes part of the public record. So it says literally everything in your will becomes part of the public record. Most of my clients don't want that. They want to keep their estate plan private. The trust is not recorded in probate or even in the county. So that's another reason to use a revocable trust plan. We're going to also look at what state did the client live in. States like California, horrible probate stories. They're very, very proactive of making sure that the trusts are fully funded. Use revocable trust almost exclusively. Colorado, we have a pretty streamlined probate process, but if you can avoid probate, why not? Now keep in mind there are still situations where I had a client recently, his wife passed away, no probate assets whatsoever, but he was involved in a business deal that kind of went south. They were in some type of litigation when she died, and to get the thing settled, it was required that he have to open up an estate for his wife just to be able to legally sign for her. So even though there was no probate assets, so things can happen, but keep those things in mind. What's the value of the probate assets? There are some states that have small estates procedures like Colorado. If you have non-real estate and your estate's less than $88,000, you can use this affidavit to avoid probate. So every state's a little bit different. Check those laws out. And then look at the clients, what's their budget? if their budget, they're trying to really watch the cost, revocable trust plans tend to be a little bit more expensive, but at the same time, if you're avoiding probate, your savings, are they really that more expensive? I would say probably not. All right, so now that we've established we're going to do a revocable will-based plan for our clients, we're going to kind of walk through some of the design questions. And I can't cover all of the design questions. There are literally hundreds of questions in our drafting software, thousands of different combinations, but I'm going to go through some pretty common ones and give you some ideas of some issues to be thinking about. So in the will is a very, even with a revocable trust plan, you're still going to have a will, which is a very simplified document that says if we happen to go through probate for some assets, pour them into my trust when I'm gone. It only addresses about 3 or 4 different real issues. And one of them is, well, who are the guardians of the minor children? I can tell you in my experience, if you got minor children, the moms don't care how much you're saving in estate taxes, how much creditor protection you're giving them. They want to know who's taking care of their babies if someone's not around. So I tend to address that issue pretty quickly. Think about who the successor guardians are beyond, the parents. What if a client's divorced? Can they completely override the ex-spouse and leave them out? Generally speaking, no. State law tends to control that disposition, but you certainly need to have backup plans for that scenario. What about co-guardians? Is that a good idea? What if you were to have, Jim and Sally Smith as the guardians? Well, what happens if one of them dies? Do you want Sally to serve alone, or do you want to have a couple? I mean, these are decisions that each client really needs to think about and decide. What if they get a divorce? We like to play a lot of what-if games in estate planning, and sometimes we drive clients nuts. But these are questions that can play out in real life. What about, here's some specific things can be very helpful. Most of the time, I find clients want to keep their children together. Be kind of unusual, like spread the kids out among the country. We don't want them growing up together. That'd be different. But sometimes they'll have special requests for educational desires. What if they want their children raised in a Christian school and educated in a Christian school, or homeschooled, or perhaps other factors? What about religious training? Want them to be raised in the apostolic faith. Well, what happens if one of the guardians you've named is no longer apostolic and you don't have that type of a provision in there, and they decide to do something totally different? Okay, so these are things that you really need to think through in your estate planning documents. Next area that a will would address would be who's your executor. The executor's duties basically are to gather the assets that are part of the probate process, pay off creditors, and then ultimately file taxes, then ultimately distribute the assets to the revocable trust. Think through who you want as your successor executors. Obviously, you're dead, or your client's dead, so is it going to be a spouse, children? Is it a good idea to have children serving together as successor co-executors? It can be, but I tell clients, do your children cooperate? Do they communicate well? Because if they don't, you're created a multi-headed monster and probably going to end up in Stan's desk in litigation somewhere. So be careful about how you name that. Last couple things that a will would address would be personal property. Years ago when I started practicing in Illinois, it was really a situation where it was kind of great for attorneys, but any item of personal property, I leave my baseball card collection, had to be in your will. I leave my golf clubs to so-and-so, had to be in your will. So anytime a client needed to change that, had to come back to the attorneys. A great thing, not highly effective and efficient for clients. So ultimately, most states use some form of a personal property memorandum, and so that can be very, very helpful. I have clients that like to try to use sticky notes. Don't use sticky notes. Not a good idea. And then the last thing is all assets are to be poured over to the revocable trust after probate. Moving on to the revocable trust, basically, is it a joint trust? If you're a community property state, probably yes. If you're in a separate property trust like Colorado, we tend to use separate trusts, but again, no rhyme or reason there. Let's talk about the trustees. If you got a revocable trust, trustees' roles and duties would be they're going to administer the trust, file tax returns, things like that. They're going to make the investment decisions for the trust. They're going to make distribution decisions. So those are the general role of a trustee. So if you got a husband and wife, are they serving together, or are they serving separately of their own separate trust? Who are the successor trustees if they become incapacitated or pass away? Those are the types of questions. had a situation recently. Client, her husband had passed away. She was the trustee of trust that he had left for her, and she is a Colorado resident, recently sold some property, has a second place, and her residency was a little bit fuzzy. Still, I think we could argue that she's still a Colorado resident, but there were some reasons. Well, ultimately what we ended up doing, some of the modern trusts, more sophisticated, we're dividing those trustee roles and having an administrative trustee do certain things, an investment trustee do something else, and distribution trustees. So in this case, we took a corporate trustee in Delaware who was going to make all of the distribution decisions and all of the administrative decisions. And then we had a financial person in Colorado, not the client, make all of the investment decisions to further distance the client from this other state that has a very high thing. One of the reasons why we did that, because there was a $50 million deal that was going to be, some assets in the trust were going to be sold for an additional $50 million. And because Delaware is a state where there's no state income taxes there, we saved about $1 million in tax. So the client was pretty happy with that result. But these are reasons why you want that flexibility in your planning. With revocable trust, oftentimes you'll talk about specific bequests or gifts. Like I give $50,000 to my friend Stan. I give $50,000 to all of my grandchildren. And this can be tricky too, even if you do, like, I leave, my residence to whoever. Is it subject to a mortgage, subject to estate taxes? These are types of questions that you go through when you're doing the design thing. What about I leave $1 million to the church I attended and was a registered member at the time of my death? What if there are no records of what church are? So you got to think through, well, what type of documentation would support this type of a gift? So some things for churches to be thinking about as well. In a common plan, again, I'm trying to go a simpler route. It gets very complicated, but let's assume that everything goes to the surviving spouse. Common marriage, what happens? Does it go outright to the spouse? We certainly can do that. But is that the best play? What if it's a blended family situation, like we saw with Abraham and Sarah? Maybe they didn't need to leave everything outright. I don't know. Do you think Sarah would leave it equally to Ishmael? Probably not. Well, what type of a trust is going to be that? Is it going to be a marital trust where the spouse is the only beneficiary? Is it a tax planning type of a trust where we have some component of where we have the children and grandchildren with the spouse? So these are some things to think about. If it's a tax planning component where you have the spouse and children, grandchildren as beneficiaries of the same trust, are the spouse's rights the same as the children and grandchildren? Do they have the same level of priority? If there's only limited assets and the grandchildren want something before the spouse, is that what your client really intended? Maybe, maybe not. How are distribution standards for income and principal determined? Mandatory income, discretionary, these are all types of design issues. Here's an interesting question. Clients often get surprised when I ask this, okay? So, because particularly long, happy marriages, what happens that if your surviving spouse, you pass away, your spouse survives, and he or she decides they don't plan on getting remarried, but they do? Are there any control mechanisms in place to protect things? You don't have to. You just kind of rely upon each other and trust each other. That's one form. Some clients will say, if you're going to, in this kind of a family bank concept, they'll require the surviving spouse, if you're going to remarry, to get a premarital agreement, which can be touchy, in order to protect the assets in case that new marriage gets a divorce. In Colorado, the appreciation on separate property is a marital asset. So it can be very, very tricky in ways of, well, how do you do this? I mean, to me, these are client types of issues that take a while to talk through and understand. What type of a rewrite power does the surviving spouse have in the trust? Is it just bolted to the ground, and after surviving spouse passes away from this trust, then it just goes equally to the children, or however it's decided? Or do we give the surviving spouse the ability to play Monday morning quarterback and say, well, it says equally to the children, but I really like this child better, or I want to give something to charity? So with a rewrite clause, or what we in the legal form called powers of appointment, can be very, very critical in the planning. What about a trust protector? Anyone ever heard of that concept? It's not a trustee. So a trust protector typically is not needed in more basic plans, although I like the flexibility that they provide. They come from the offshore trust world, but basically their role is to help keep things out of court, minimize conflict, and add flexibility to plans. In Colorado, I can create a trust, in theory, not in theory, in reality, that can last up to 1,000 years. That just seems, it kind of blows my mind. I can't quite get my mind around that. 1,000 years is a long time. Obviously, whatever we thought was going to be the ideal plan won't be the ideal plan in probably 50 or 100 years. So we need somebody to step in and add some flexibility. A trust protector concept allows a trusted individual person to kind of come in, keep things out of court, minimize conflicts. Those are things I like to include in my plans. Distributions to children, outright or in trust. Obviously, if they're minors, definitely should be in trust. If they are adult children, should they be outright, keep it simple, or should they be in trust? Well, it depends. What's the goals again? To me, some of the benefits of trust include helping the beneficiary, might have a spendthrift child, to manage the assets. Creditor protection, divorce protection can play again if that's a goal with one of your clients. Potential future estate tax savings. I mean, in these kind of long-term dynasty trusts can go generation upon generation. No estate taxes can be huge compounding effect. And also, if it helps if you leave assets in trust, if it's a significant amount, can minimize the work that your children have to do as far as incorporating that into their own planning, because you can set some predefined criteria within the plan itself. So it depends upon the client's goals. I tend to see, some combinations. For more basic plans, I often see a staggered distribution to children. I think the thinking is, as children get older, their brains are more fully developed. So maybe one-third of the trust is distributed at 25, another third at 30, and they get the balance at 35. But there's some problems with this. This works at a basic level, but it does not give you creditor protection, divorce protection, does not give you estate tax savings. So if you want those other benefits, you need to do a lifetime type of a trust to maximize those other benefits. Who should be the trustee of your kid's trust? Should it be a sibling? That can lead some interesting conversations at Thanksgiving. Should the beneficiary have a right to serve as a co-trustee at some point in time, or even a sole trustee at some point in time? Those are some things that can be very, very important. And same types of, I even have, this, to me, I don't see the marital agreement requirements for children as often as I do for surviving spouses, but I do see it occasionally where some clients will say the child cannot be their own trustee until they have a marital agreement in place. Or I think the most egregious one that I have had is the client said a child cannot even receive distributions from the trust until they have a marital agreement in place. Makes me a little nervous. Could that be challenged? I don't know, potentially, but he was very, very kind of controlling in that way for certain reasons. Moving to the latter part of the trust types of discussions, one of my favorite parts that clients tend to spend way too much time on, the Titanic clause. So this would be, your family's taking a cruise, hits the iceberg, and all of your immediate family, kids, grandkids all pass away. What happens to your estate? Well, a lot of times it's just to my closest family members, whether it be parents, brothers, sisters, nieces, nephews, kind of down the family tree in that way. Other times it's charities, maybe it's to son-in-law, daughter-in-law, provided that they're married. Sometimes you got to think through those types of criteria. It's always good to have these in there, but clients, in my experience, spend way too much time on this because I've only, in 32 years of practice, I've seen this happen twice. So have the clients think it through, but don't spend too much time. Last couple issues that you want to think about, well, if we run out of trustees, I like to generally see 3 to 4 types of fiduciaries, but ways to additional trustees can be appointed and removed if there's conflicts. I like to even have, for children, if you're doing a lifetime trust, to toggle the control aspect of their design. So if you say, well, I'd like to turn over the keys to the kids when they're 35, for example. Well, who can they leave their share of the trust to if they were to die prematurely? And oftentimes clients will say, well, I don't care who they leave it to. Well, what if they're 19 years old, like my son is? I don't want him leaving his $2 to, I mean, I'm controlling, but he probably would not make the best choices. What I tend to see is clients, as children get older, they tend to say, well, they have more restrictions if they're younger, below age 35, for example. We're going to say they can leave it to other family members or certain charities. Once they get over age 35, they can leave it to anyone in the world. So kind of toggle that control as you wish. The last couple documents we're going to cover is just the powers of attorney. First have the financial power of attorney. This is the document that authorizes someone to make financial decisions for you should you become incapacitated. And obviously what I see is typically the executor, trustees, the agents under financial power of attorney tend to be the same. They don't have to be the same, but the roles tend to overlap. So you have a lot of the same types of issues. Who should you name? Should you name co-fiduciaries? Think through those types of contingencies. When is the power of attorney effective? Is it immediately upon signing or upon incapacity? There's pros and cons in that situation. What types of powers are you granting under a financial power of attorney? Tend to see things that are very, very broad in nature, pretty much anything that the principal could do, the agent could do as well, but there tend to be some specific powers that have to be really delineated in the document, such as the power to make gifts beyond your $19,000, that tends to be, or the power to amend your revocable trust. That can be very powerful. They can literally change your estate plan. Do you trust someone well enough to give them that type of a power? Here's from a church perspective. What about giving them the power to continue to pay tithes and offerings? Would that be covered or not? I don't know. Those are some things to think about. Moving on to the medical power of attorney, this would be a document that authorizes someone to make medical decisions for you, long-term care, life support types of issues. They don't have to be the same as your financial power of attorney agents. They can be different, and oftentimes they are. Depends upon if you have a doctor in the family, a nurse in the family, someone who's closer. A lot of reasons why people make those types of decisions. So again, long-term care, life support types of decisions. Does the client want a living will? In Colorado, our living will says two scenarios. You have a client who's stating forth their end-of-life wishes. If two doctors have determined that you have a terminal disease or illness, you're unable to make your own decisions about life support issues. What are your wishes? Is it discontinued? Is it continued? For how long? Those types of issues. If you're not in a terminal state, but you're considered brain dead, then what? This also raises some very interesting spiritual and practical financial determinations too. I had a client years ago who wanted to be on life support as long as the insurance paid for it. Thankfully, I was able to talk her out of that one, so that was not a test case. So lots of interesting scenarios. All right, so we're kind of quickly through the design. Now what? Got a lot of action items, a lot of notes, a lot of things. Well, what do we do with these? Well, you want to capture those action items, the notes, as quickly as best you can. What do we do as far as how do you get documents to the client? When I first started practicing, would just send drafts out. Nothing wrong with that. But I always wondered why it took clients forever to get back to me, because who wants to sit down on a sunny Saturday afternoon and read your estate planning drafts? Not good. So as the documents have gotten longer through the years, I've been using an executive summary in my approach, and I send out kind of this outline of what the high-level documentation would be before we draft any legal documents. And then once the clients confirm that blueprint, then we go to drafts. But again, everyone's different. I found that clients love pictures, flowcharts. When you start talking about all these trusts, I start glazing over. Pictures are great. Use pictures. So you're going to review the estate plan, confirm everything. They're going to sign it. Don't forget to coordinate the titling of your assets with the documents to make sure your beneficiaries are correct, you're funding your revocable trust. Well, how often should you be reviewing your estate plan? My general rule of thumb is every 3 to 5 years, unless you've got changes in your financial circumstances, changes in your family, changes in the tax law. So there's a lot of reasons to stay on top of these types of issues. All right. In my last couple of minutes, I wanted to point out a couple other things. How many is familiar with a donor advised fund? So I know the UPC, I believe, still offers that through the UPC, if I'm not mistaken. But it's basically a way of having your own mini foundation that you can name basically whatever you want without having the cost and complexity of having your own foundation. And I've had clients use these for as long as I've been practicing. I established one myself with our family several years ago. And this is a great tool not only for yourself, but for families to do all of your charitable giving through. Even our church giving, we do all through this donor advised fund, because you get the income tax benefit. Not that's why we give, of course, but when you give it, that's what really matters, and you don't have to give it all away immediately. You can scatter it out among whatever charities, whether it be Tupelo's Children's Mansion, to Compassion, any ministry. So check out the donor advised funds. They're really great tools. I've got a slide in here about creditor protection as well. Creditor protection is a sliding scale. It's not an all or nothing thing. There's different tools, so depending upon the level of creditor protection that you need, don't use too much. I used to have a former colleague used to say, don't put a jet engine on a Jeep. So be careful with the creditor protection. It's always good, it's helpful, but don't overdo it. And then there's a lot of slides in here. We like what I call the alphabet soup. These are kind of advanced planning tools. ILETs, SLATs, GRATs, CUPERTs, CLTs, all these types of acronyms. These are more advanced estate planning tools. I'm happy to discuss with anybody if you got time to, and you can't sleep tonight, feel free to browse through this. We'll put you right to sleep. But they're cool tools. You can move a lot of wealth, minimize taxes, and accomplish clients' goals through the use of these tools. So thank you again. Anyone have any questions? We've got a couple of minutes. Thank you.
Thank you very much, Brother Bland. We appreciate your expertise and your presentation. If you do have questions for him and you'd rather ask them personally, you can do that at dinner tonight, or if you don't mind being in open tomorrow during our question and answer attorney panel after lunch tomorrow, you can do that. Let's take a 5-minute break if we can. Restrooms are down the hall to your left. There's some coffee and drinks there, and we'll let the next speaker get set up. Thank you.